Welcome to the first episode of our brand new web series called Leading Questions. I'm Megan Mah.
I'm Kayla Theeuwen.
And I'm Sydorenko, and we're lawyers at WeirFoulds. Leading Questions is a web series where you ask us everyday topical legal questions and we answer. And even though we're a chatty bunch, us lawyers, we're going to keep it short and sweet for you.
Our first episode features a number of lawyers from WeirFoulds who are here to answer pandemic-inspired questions. We are fully aware that COVID fatigue is a real thing, and so we're going to do our very best to keep our use of the C word to a minimum.
Today we'll be answering questions about contracts, employment law, multi-jurisdictional issues, and health law. So without further ado, let's get to episode 1.
Woo! Okay, episode 1, here we go. Okay, Ashima, this question is for you. So I'm currently in a contract for a gym membership, and obviously I'm not going to the gym because of the pandemic. What can I do?
Yeah, I'm also curious about contracts for preschool or daycare. How are those affected?
You're right, there are a number of services that this could apply to, whether you're worried about your gym membership, your child's daycare, or maybe you're planning a wedding this summer and you have various contracts with different vendors, or even just taking a cooking class or something like that that you're worried about. The first step is to always review the contract you have with a service provider and look for specific clauses.
Okay, Ashima, but we all know that lawyers are the only ones who read contracts top to bottom. Are there any specific clauses that people should be looking out for?
For sure. So there are 3 clauses that you can look for. The first is a force majeure clause. These are common clauses in contracts that dictate what happens when there's an extraordinary event or circumstance beyond the control of the parties, such as a pandemic or war, strike, riot, crime, epidemic, any event that's described specifically in the clause. These clauses may not always specifically include a pandemic, definitely not COVID-19 directly, but it's always a good place to start. In practice, most force majeure clauses do not excuse a party entirely, but usually suspends the providing of services and related payment during the force majeure. The second clause is a remedy for non-performance clause. Even if you aren't qualified under a force majeure clause or there isn't one, current government restrictions may make it impossible for certain service providers to perform under the contract. However, as we all know, when you enter into a contract, you're legally obligated to perform your contractual duties. That is, do what you promise to do in the contract. Non-performance is the failure to perform these obligations. So the clause will specifically say that if I can't do this, or if one of the parties can't perform what they need to do, this is what the alternative is. We see this now with gym memberships going online and somehow expecting us to sweat in our living room and make it equivalent to us going to the gym, or cooking classes over Zoom, et cetera, et cetera. This works for some people, doesn't always work for others. The last clause that you should look at is a termination clause. Maybe you're in a situation where it's just not working for you, you don't see it happening, and you need to terminate the agreement. But you need to look at this clause to see what kind of notice period you need to give. So maybe you have a year-long membership and you're 6 months in, but there's a 1-month notice period. It's much better to give that 1-month notice period, pay 1 more month, and get 5 months of non-payment or not having to deal with it, rather than waiting a long period of time and then having to pay the whole year.
Yeah, and it can be really frustrating, I guess, for a lot of people because you can't get out of your contract, but you also don't want to lose your deposit.
Yeah, I know. See, you have to remember that in this situation or in a similar situation, we're kind of all in it together. So you might be worried that, oh my God, I don't want to lose my deposit, but other people or the service provider is worried, well, okay, maybe I get to keep the deposit, but I lose future payments on this contract, or I get a bad reputation because people are mad at me now. And in the wedding industry or any other industry, you don't want to get that kind of reputation for repeat clientele. So with that in mind, always try and work with your service provider, talk to them and try and renegotiate terms or an entirely different agreement.
That makes a lot of sense. Thanks, Ashima. So on a related point, I have a question for Julia. If someone is renegotiating an existing contract or entering into a new one, what are some of the terms that they can add to that agreement to protect themselves as the purchaser?
Great question, Cecile. So when it comes to the kinds of contracts that Ashima just talked about, wedding vendor contracts, extracurricular activities for your kids, daycare, tutoring, cleaning services, daycare, doggy hotel services, the biggest challenge right now is enforcing those contracts.
Right, because courts are closed right now and most likely will be backlogged when they reopen.
And people want to be able to plan or replan their wedding or ensure that they can enroll their kid in the daycare of their choice before it fills up.
Exactly. So before anybody signs on the dotted line, the first thing you should work out with your service provider is what exactly is going to happen to your money or your fees payable if the service provider can't provide you the services exactly as you're contracting for them. For example, when I was planning my wedding pre-pandemic, one of my vendor contracts said that if I can't get my services on the day of my wedding, that I can move my deposit to a later time to receive the services at a later date.
Wait, what? So, oh, you don't need a string quartet or a harpist to play at your next birthday party.
Or like, please do my makeup for my next court appearance.
Seriously.
Yeah, you know what? I've been known to indulge once in a while, but even I'm not that extravagant. So I asked them to kindly remove all the clauses that said that revolved around that, and said, listen, if you can't perform the services on the day that I'm contracting it for, it's only fair that I get my money back. And lots of wedding vendors actually do the same thing. So you should really work out what happens to your money or your fees payable in the event that the government restrictions prevent your service provider from performing the services as promised. Obviously, the most preferable option is for you to get your prepaid amounts or your deposits back, or put a stop to your payments in the future.
So Julia, what if you are more flexible though on the timing of when you get your services?
Right. So for example, let's say you're contracting to get some sort of remodeling done to your home. If you're okay with getting those services at a later time, that's fine. You can contract that, but you should still put a time limit. So let's say 6 months. And then if they can't perform those services within those 6 months, then you should get your money back so you can reassess your situation at that time.
Okay, but what happens once the restrictions are lifted, as we're seeing now? Anything else that we should be thinking about?
Right. So the second thing that you should be thinking about when you're contracting is getting an acknowledgement from your service provider that this contract is being entered into in the context of declared pandemic. So the service provider should promise that they're not going to use a pandemic as a reason to raise prices on you, that they're going to implement all measures implemented by a governmental authority, and that they don't expect the pandemic from preventing it from performing its services once the restrictions are lifted. Another thing you should negotiate is your payment terms, how you're going to pay it, when you're going to pay everything, but that's a loaded question, so I'm going to save that for a future episode. The bottom line is we're in a pandemic and the future is very uncertain. And that makes it really hard to plan your life, but life just keeps on trucking. Whether you want to get married at some time in the future, or replan your wedding, or put your kids into daycare, sign up for some classes, remodel your home, it's more important now than ever to work out what's going to happen to your money, whether it's your deposit, your prepaid amounts, or the fees payable in the future. If the service provider can't perform their services, if the restrictions aren't lifted, or if the restrictions are lifted, that the service provider agrees it has a plan in place to give you the services as promised. That's all for me.
Thanks, Julia. That's so helpful. Kayla, our frequent flyer, what's it like being in Toronto for so long?
I know. I never thought I'd actually miss traveling for business, but...
Yeah, I'm sure. I know you love it. I have a question for you, though. So what if I'm a Canadian citizen, but non-resident for income tax purposes? Say I came home to Toronto before the borders closed, but now I don't know when I'm going to be able to leave again. Should I be worried?
Yeah, so it's an interesting question, and it's come up a few times since international borders around the world just closed and we all got stuck where we are. So before I get into the meat of this answer, I must state for the record that I'm not a tax lawyer. I don't have any special tax expertise. I took baby tax in law school, and that was more than enough for me.
Same.
Yeah, it's just not my thing. So I'm a commercial litigator, and whenever tax issues arise in any of my files, I get the appropriate professionals involved. So then you might be wondering why I'm answering this particular question. It's come up for me because my practice is multi-jurisdictional. So I practice in Ontario, but I'm also called to the bar in a number of jurisdictions in the Caribbean. So I work with lawyers and professionals all over the world.
Meaning you basically sit on a beach drinking rum punch all day, right?
Yep, exactly. You know me so well. So some of my colleagues have re-domiciled for work or for their spouse's work, and so their tax situation and their tax residency becomes a little bit more complex and a little bit more important for income tax purposes. So where they are resident might be very important from a tax planning perspective. So generally speaking, under the Canadian income tax system, an individual's liability for income tax is based on their status as either a resident or non-resident. So at a very, very high level, remember, not a tax lawyer, residents are subject to Canadian income tax on worldwide income from all sources. On the other hand, non-residents are only subject to Canadian income tax on income from sources inside Canada. So there are a couple of bilateral treaties between Canada and some other countries that address some very specific issues, but those are beyond the scope of today's discussion. So how does somebody become non-resident? I mean, it sounds pretty straightforward. Obviously, there are some intricacies to take into account, but basically someone becomes non-resident by leaving Canada to live in another country and by severing all ties with Canada. And so the CRA will look at the residential ties that you have or that you severed in order to determine your tax residency. But in addition to looking at residential ties, the CRA will also look at the number of days that a person has worked, studied, or been on vacation in Canada as part of its analysis.
Kayla, is there a magic number for that?
Yeah, so it's 183. So take 365 days in a calendar year, divide it by 2, and add 0.5. So literally just over 50% of the tax or the calendar year. Okay, so getting back to the question, a person might have taken all steps to become non-resident. They leave Canada, they sever their ties to Canada, but then they get stuck somewhere and they could be deemed to be resident for income tax purposes because they've been in Canada for 183 days or more in a tax year.
Right, yeah, insert global pandemic.
Yeah, exactly. So borders closed, you get stuck in Canada, you end up for this calendar year being here for over 183 days. You start to panic because you think you pay enough tax already and you don't want to be deemed to be a resident here and then have to pay more income tax. Fortunately, the CRA recently released a guidance on international tax issues raised by COVID. So among other things, the guidance says that the CRA will not consider an individual to be resident in Canada where they've remained here solely because of travel restrictions due to COVID. The guidance is very specific to COVID. It's not just if a border closes down a few months down the road, this is going to apply. It really is just about COVID. And so in addition to that, the CRA also says that it will not consider the days that an individual is present in Canada and unable to return to their country of residence solely because of travel restrictions to count towards that 183-day deemed residence test. So I have now said the C word a few times, and I think that's enough for me.
So tax residency is important. Got it. So moving on to employment. Megan, what if we're afraid to go to work because of COVID? What are our options?
So employers have a duty to make sure that the workplace is safe and to take all safety precautions that are reasonable in the circumstances. So what's considered reasonable will vary depending on the individual workplace, and safety measures will vary from case to case. But the government has released individual sector-specific guidelines that workplaces should follow to make sure that the workplace is safe.
So if my employer is not following the guidelines, then I don't have to go to work?
Good question. If you're afraid to go to work because of COVID-19, you can't just not show up to work without saying anything. So there's a specific process that employees have to follow, which involves a dialogue with the employer and a discussion and possibly an investigation by the Ministry of Labor.
What if you're pregnant or have some other kind of underlying health condition?
So depending on the nature of your concerns, your employer's human rights obligations may also be triggered. So for example, if you have an underlying condition, or if you have childcare obligations, or if you're pregnant, this may make you more susceptible to COVID-19 and you may require accommodation under the Human Rights Code. But the bottom line is communication is key. It's really about communicating your concerns with your employer and having that good faith discussion about how your concerns can be addressed. You can't just not show up to work without saying anything.
Okay, that makes me think of another employment-related question, and I think Leah will have the answer for it. Can my employer reduce my salary?
So the answer to that is really that it depends. So normally a reduction of your salary is not permitted and could be considered a constructive dismissal, but often a temporary reduction in your salary of, let's say, 10 to 15% was not always considered significant enough to be a constructive dismissal. So with the pandemic, we see a lot of employers who have, as a result of significantly reduced revenues, they've been reducing employers' wages or employees' wages or hours to deal with that. And it was kind of unclear for the first couple months of how this was going to be dealt with in the courts or once the pandemic was over. But we got a little bit more clarity on May 29th. The government released new regulations which said a temporary reduction in wages as a result of COVID-19 would not constitute a constructive dismissal.
Okay, but COVID really feels like it's lasting forever at this point. What does temporary even mean?
It's a really good question, and it's a kind of an annoying answer because we don't really know. Temporary is not, we don't know what temporary means. We don't know if that means it has to be lifted. The reduction has to end once the pandemic's over, the state of emergency is over. Courts, it's going to take a while for a court to explain what it means. But at this point, the best thing you can do is if your employer tells you it's reducing your salary, confirm that it's only a temporary reduction, even if they don't define what temporary is. And if they don't confirm that the reduction is temporary, you may want to consider telling your employer that you'll agree to the reduction for now if you feel like you don't have a choice, but you'll agree to the reduction for now on the understanding that you'll be repaid once revenues or cash flow return to normal.
I feel like that would be a really awkward conversation to have.
Yeah, but it's an important one. So.
Speaking of important, so many people are worried about healthcare services at a time like this. The last question for today is for Ada. Can I go see my healthcare provider?
That's a great question. So Ontario Regulation 8220 under the Emergency Management and Civil Protection Act allows regulated health professionals and professionals or organizations that provide in-person counseling and services to be open. So these providers, like other businesses in Ontario, they can now open, but they have to continue to follow the directives given by the Chief Medical Officer of Health under the Health Protection Promotion Act. And the regulated health professionals also have to follow the guidance of their regulatory college. So the directives give healthcare professionals precautions to follow in order to minimize the spread of COVID-19, and they offer some guidance on restarting. So healthcare professionals might be considering which services can continue to be provided remotely and which services can safely resume in person with appropriate hazard controls and sufficient PPE, which I'm sure is another acronym that you're really sick of hearing. So when it comes to making decisions related to gradual restart of services, healthcare providers will be using principles of proportionality, minimizing harm to patients, equity, and reciprocity. So what does this mean for you? It may mean that your healthcare provider will screen you over the phone or in person for COVID symptoms, and they'll be using PPE, possibly including gloves, face shields, and gowns for interactions with potential COVID-19 patients. And depending on the health procedure, they may be taking airborne precautions when aerosol generating medical procedures are planned or anticipated on potential COVID-19 patients. Consequently, if you have a medical concern that you'd like to seek in-office treatment for, you can go to your medical professional's office if they're open, as long as they're able to operate in accordance with the directives from the Chief Medical Officer, as well as the guidance from the Regulatory College. It'd probably be best practice for you to contact your healthcare professional ahead of time prior to your appointment to explain your concern and to ensure that your professional is able to operate in a safe manner.
Okay, so probably not a bad idea to contact your healthcare professional before your appointment.
Exactly, and also not a bad idea just to bring your own PPE with you.
That brings us to the end of episode 1. Thank you, ladies, for all your wonderful insights, and thanks everyone for joining us. As always, if you've got any questions for us, feel free to email us at leadingquestions@weirfoulds.com. See you next time.